Southwick had another obligation in Houston, so he is appearing remotely. But I believe, at least judging from the way it went with another judge this morning, we'll be able to hear him if he has questions. I'm sure you're all quite familiar with our traffic light system and our rules. In this case in particular, the citation of record excerpts will be very, very helpful to us, because as you know, we don't ordinarily have FERC cases. You know, when the FPC became the FERC in the late 70s, I used to quip Nunder, call it FERC, but I was wrong. Okay, this is case number 1860575, El Paso Electric versus Federal Energy Regulatory Commission. We'll hear first from Ms. McCormick.
Good afternoon, and may it please the court. I'm Marnie McCormick, here on behalf of petitioner El Paso Electric Company. The core issue in this appeal is whether FERC is violating the Federal Power Act's prohibition on unjust and unreasonable rates by mandating a cost allocation scheme that encourages free ridership in WestConnect. The problem here is FERC has mandated a process that allows both jurisdictional and non-jurisdictional utilities to participate equally in the process of proposing, designing, and voting to select group projects that meet their individual needs. But at the same time, FERC has given the non-jurisdictionals, which comprise roughly half the region, the right to opt out of paying their part of the costs. This court vacated FERC's mandates in 2016 and held that this scheme is unjust and unreasonable unless FERC can show why the obvious economic incentive to get something for nothing will not operate as expected in WestConnect. On remand, FERC just reinstituted the same scheme and repackaged the same justifications that this court rejected in 2016. I plan to touch on all three of the reasons that FERC gave for its orders in WestConnect on remand. The first is FERC says it can sacrifice the cost causation principle to further what it calls a competing interest in getting more transmission projects built. But the cost causation principle is not a mere policy goal. It's the essence of a just and reasonable rate. And the Federal Power Act flatly prohibits FERC from adopting unjust and unreasonable rates. Whatever FERC does, it can't violate this statutory mandate.
Ms. McCormick, can you hear me?
Yes.
I guess the audio is working. Excuse me. It seems to me you're making cost causation, at least your argument lends towards saying cost causation is the dominant consideration that FERC has to provide. I think our earlier panel, the D.C. Circuit, and certainly FERC, indicating it's one of the considerations. Why should that have a greater weight than other considerations? I mean, just the opposite of free riding. Why should not having free riding be so dominant?
I'm having a little bit of trouble hearing, but I think I just want to confirm you're asking why should the principle of cost causation dominate over other policies that FERC hopes to support? Because the statute gives FERC open-ended authority to make policies to support the development of transmission in the country. But the statute is very clear. There is no, it's not a policy goal that FERC ensure that rates adhere to the cost causation principle. The statute is black and white on that issue. FERC may not adopt an unjust and unreasonable rate. And the courts and FERC have both determined that the words just and reasonable mean FERC must comply with the cost causation principle. It's a statutory requirement, and it is a black and white issue. So
It's a black and white issue, but as with most computations and predicting in advance, it is somewhat unpredictable how things will work out. I'm sure the rest of your argument will address that, but it does seem to me your principal objection to what FERC has done is that it's relying on its own predictions rather than hard evidence as to how all this will play out. Is that a fair assessment?
that's FERC's attempt to justify these orders is based on what it says is a prediction about how non-jurisdictionals will respond to the scheme.
Proceed.
So,
Proceed.
okay, on the last point, I just wanted to point out that FERC made the very argument that I just spelled out in the first appeal to this court. And the court did acknowledge that FERC said it was weighing two competing policies, but this court still vacated the compliance orders. So nothing has changed in the facts or the relevant law on that point, and it wasn't an adequate justification in 2016, so it shouldn't be today. But FERC's second point is that even though no non-jurisdictional has enrolled and subject itself to binding cost allocation across the board, FERC expects the cost-benefit formula in the West Connect tariffs will incentivize non-jurisdictionals to volunteer to pay on a project-by-project basis. But there's no evidence in the record that this will actually happen. It is just speculation. And there's no economic theory that supports FERC speculation. In fact, the premise of Order 1000 was that without regulatory intervention, utilities do take advantage of the opportunity to avoid paying when they can. So FERC's focus on this cost-benefit test is not compelling. The cost-benefit test in the tariffs is just a mathematical formula, and there are...
I have a couple questions about that. You listed these 9 or 10 non-jurisdictional utilities, and several of them caught my eye as belonging to rather large population centers in the West Connect area, such as Los Angeles, San Diego, Sacramento. Aren't those quasi-utilities, in other words, they're either owned by the municipality or regulated by the municipality for the benefit of the populations in those areas, or am I wrong?
I do not know the answer to that question.
Well, don't you think that would be a pretty significant question? Because if LA, for instance, regulates water rates, I think it's the Water Regulation Agency that's non-jurisdictional here. Is that right? It's your list at the beginning of your brief of the non-jurisdictional utilities. It's in a footnote.
Right, and these are electric utilities because...
Okay, well, I thought one of them said something about water, but all right, fine. I'm trying to be accurate. Okay, say it's an electric utility for San Diego. Is San Diego one of them?
I can't list the non-jurisdictional utilities, but...
Well, my point is this. If they are separately regulated at the local level, which is what makes them part of their being non-jurisdictional, could they legally voluntarily bind themselves enrolling in this planning procedure if Order 1000 says you absolutely don't have to enroll? What would the ratepayers and the regulators at the local level have to say about their voluntarily undertaking not to be free riders?
It is possible that some of the non-jurisdictional utilities would not be able to volunteer to pay their share of costs on a project-by-project basis. I have not looked at that and can't confirm
well, since that's a matter that we could take judicial notice of, you might file a 28J letter and just point out whether or not those are regulated.
Okay, thank you, Your Honor.
Another question I have is, are these here's where it is. Los Angeles Department of Water and Power, Colorado Springs Utilities, Arizona Electrical Power Cooperative, Basin Electric Power Cooperative, Sacramento Municipal Utility District. So Public Service Company of, well, that's Colorado in support of El Paso, but anyway, those are the non-jurisdictional ones. How much electricity do they use vis-a-vis the jurisdictional utilities here?
I will submit a letter, find the answer, and submit it.
Well, one of your arguments is that this is a different case than the South Carolina case, in part because you have a much larger share of non-jurisdictional utilities in the mix here.
And it's become apparent since that dispute about Order 1000 that the non-jurisdictionals will not enroll. It's been over 10 years.
Well, I understand that, but if their total electricity consumption was about 10% of that which the jurisdictional utilities serve, then the case to me would be more similar to the South Carolina case.
Your Honor, may I?
Please answer.
In the South Carolina case, the type of free ridership that was at issue was spillover benefits from, there would be a regional process where costs and benefits were quantified, but there were some accidental, unintended benefits outside the region that FERC did not provide for a cost allocation method in that situation. And the DC Circuit concluded that that was permissible. But that's a different situation from what we have here. Here, the regional process quantifies exactly how many costs and benefits are for each utility, both jurisdictional and non-jurisdictional. These are intended benefits that FERC is ignoring in its cost allocation decisions.
Okay, well, you have an opportunity for rebuttal.
Thank you.
Mr. Skees?
Good afternoon, Your Honor. John Daniel Skees, counsel to one of the interveners supporting El Paso Electric, representing Xcel Energy Services and its operating company affiliate, the Public Service Company of Colorado. The interveners supporting El Paso today asked for time to speak to address two issues. The first is that FERC has imposed a tariff on the public utilities in West Connect that is fundamentally inconsistent with the Federal Power Act, which requires that all rates be just and reasonable, which, as this court in 2016 explained, requires that all costs and benefits for transmission projects be roughly correlated. That is simply not what has happened here. Here we have non-jurisdictional utilities that have a full seat at the table equivalent to the public utilities. They have the same vote in all of the governance rights, and all of their transmission needs are planned for in the same manner as if they were public utilities. If in the event West Connect identifies the need for a transmission project that will serve their needs, they have the opportunity to participate and pay into their allocated portion of those costs, or the non-jurisdictional utilities can step back and say, we choose not to pay. In that instance, it's not that those benefits will not accrue to them. Instead, the public utilities, and most importantly, their ratepayers, will be forced to pick up the entire portion of the cost of those projects. And Your Honors, on every month, the ratepayers of the public utilities receive a bill. Part of that.
Counsel, can you hear me? I was muted. I was trying to stop you before you got going on the next part. Seems to me you would skip one of the steps, which is you still need the cost-benefit ratio to be 1.25 to 1 after you take out the non-participating, non-jurisdictional utilities. FERC says, we think this is going to work. The interconnectedness of this particular area of the country and electric transmission has made this work in the past. I know one of your briefs responds to why it's not a direct correlation to what happened in the past, because nobody was required to participate, pay costs in the past, is my understanding. But it does seem to me FERC is saying, based on our expertise, we think this is going to work. And it's not, like you said, that whoever doesn't agree gets a free ride. They get a free ride if the project goes forward, and FERC says most of the time that won't happen. So I guess in a way, how do we know that's wrong? And regardless of it wrong, and can you say it doesn't matter if they're wrong or right?
Thank you, Your Honor. So on the first point, why, fundamentally, this is not something on which the court should defer to FERC, really for two reasons. The first one is that FERC's economic theory, there is no actual evidence in the record there as to, why there would be participation, historical evidence, anything like that. Instead, it's FERC's economic theory that the non-jurisdictional utilities will choose to pay even though in at least some of the circumstances they could get the same benefits for free. And it's not a valid economic theory to expect that people will pay for things that they could otherwise receive for free. The second reason not to defer to them is that they're dealing with the expected behavior of utilities that they do not regulate. As Judge Jones pointed out, these are unique entities across the West in the southwestern United States that have their own regulatory regimes, of which FERC has no expertise whatsoever. And so the idea that the court would somehow defer to FERC on the expected behavior of entities that they have no regulatory history of just simply lacks a reasoned basis to expect that that will happen.
Is there any, how were enlargements of the transmission capability done in this area in the past?
Your Honor, historically before Order 1000 and the binding requirements, it was done on a voluntary basis. And in fact, that was what the public utilities originally proposed, is that there would be the ability to continue to participate by non-jurisdictional utilities, but that everybody would have an opportunity to opt in or opt out. FERC rejected that, but historically that is how it happened.
And no ticky, no laundry, to use a politically incorrect expression, right?
Everybody had to pay their way, right? Everybody had to agree to pay
or not participate.
That's correct, Your Honor.
And did that happen under the auspices of FERC regulation before Order 1000?
Prior to Order 1000, FERC did not regulate regional transmission planning in the way it did with Order 1000. You had to have a process, but there was no cost allocation component whatsoever.
So that was the big innovation in Order 1000.
It was certainly one of them, Your Honor.
Well, then why wasn't it a necessary feature of that to embody, Section 211A?
Your Honor, that was one of the issues that was raised before the D.C. Circuit. FERC chose not to, and the D.C. Circuit concluded that FERC did not have to use 211A. But as we explained in this proceeding, FERC has claimed that they're somehow stuck between a rock and a hard place, that they cannot allocate these costs because these entities are non-jurisdictional, and therefore they need to have this sort of ability for free ridership. That's not the case. They could have chosen to use 211A, and even FERC in its orders says we could use it, maybe we will in the future, but we have chosen not to so far.
Okay, did you have any other points to make?
Can I have just 30 seconds to make one brief point? In 2016, the court recognized that the existing tariff, that's the exact same tariff before the court now, allows the possibility of significant material-free ridership that could be tens, if not hundreds of millions of dollars. And they sent it back to FERC and said, FERC, it looks like this has free ridership that violates cost causation. Explain why it doesn't. What FERC said very explicitly in its orders on remand is yes, sometimes it will result in free ridership. They failed to quantify it, and therefore they failed to respond to the 2016 directive, and their orders should be remanded again with more precise direction. Thank you, Your Honor.
Thank you. All right, Ms. Banta?
Good afternoon, Carol Banta for the Commission, and I'll begin by going back to some of Your Honor's previous questions. Judge Southwick, in particular, Your Honor, you were asking about why cost causation should be a dominant consideration, and the D.C. Circuit how it has looked at the balancing. I want to make an important point about what has been characterized as a mere policy goal of Order 1000, of ensuring that there are more identification of more efficient and cost-effective regional projects. Although even the orders tend to refer to that as the Commission's policy goal, to be clear, the premise of the Order 1000 rulemaking was a finding under Section 206 of the Federal Power Act that the existing processes were unjust and unreasonable. So the encouraging and promoting of better regional transmission planning is not a mere policy goal. It's actually something that the Commission found necessary to produce just and reasonable rates, because ratepayers were paying too much. Because if more regionally beneficial projects could be identified, then ratepayers would pay less for transmission. And that was a core finding in Order 1000.
So you're planning to implement to require free riding so that ratepayers in the jurisdictional utilities will pay even more?
No, we're not requiring free riding. And to be clear,
Well, I don't see any way that you can avoid free riding here. And don't you think that, I mean, what's the point of all these settlement discussions that have been going on? I gather those are between the jurisdictional and the non-jurisdictional utilities, and if there were some way that the non-juris, and we'll hear from them in a minute, but that they could be satisfied that they were going to participate, they have ultimately no incentive to do so if they're not required to pay part of the cost.
Well, except that they do, and that goes to the discussion of the cost-benefit ratio, and the reason that the Commission explained why the process of reevaluating if the non-jurisdictionals on a particular project decline the cost allocation, checking to see whether it's still sufficiently, like 125% benefits to costs for the jurisdictional utilities, the Commission explained why the math is limiting of free ridership. Because, as the Commission said in several places, if the proportion of the benefits on a given project are weighted too much to the non-jurisdictional utilities, then the project will not go forward without their participation. It's only in the cases, and to be clear, there hasn't been a single project, there hasn't been a regional need or proposed project identified in the West Connect region in the first 5 planning cycles. The first 2 happened before these orders, there have been 3 more. So we're talking entirely hypothetically because there has been...
in 10 years, right? In 10 years since Order 1000 has come out, there has been no regional planning to upgrade transmission?
In West Connect.
I understand that, but that's a large share of the western United States.
Geographically it is. It doesn't match up to some of the larger planning regions.
But as people leave California and go to Colorado, Montana, Arizona, Idaho, and so on, there's obviously going to be a need.
Well, what hasn't been identified are any regional needs, the way that's defined in the tariff. It has to do with transmission projects that could be addressed by multi-utility projects. I don't know the reason for that. We don't have the record for that. I pointed out only because we're speaking entirely hypothetically in this case, because there hasn't been a case where there's been a proposed project with 3 jurisdictional utilities and 2 non-jurisdictional.
That means that Order 1000 is a total failure, because if there are no proposed projects, then Order 1000 has certainly not stimulated them.
The Commission has not called it a failure. It does monitor how it's being applied in different regions, and it has taken action in other regions when it thought Order 1000.
And that's part of their argument. The West Connect system is just not like the others. You can correct me if I'm wrong, but what I'm recalling from the briefs at least is that it's much more spread out. There are 10 non-jurisdictional utilities. Common sense would say that a bunch of those are very large electricity consumers, so that the potential adverse impact of free riding is huge.
Well, except that actually goes to why the mechanism here would be limiting. Because if one of those, and we have to think in terms of hypothetical projects. It's very unlikely. I don't know if you'd ever see a regional project that would involve all 21 players here. So it's not going to be 50-50. It might be something like 3 jurisdictionals and 2 non-jurisdictionals. and we wouldn't,
Well, give me an example of that. There's nothing in the briefs about it, but from my own enlightenment, give me an example.
well, because a regional reliability need could be something like an extra high voltage transmission line that spans a couple different, several different territories, that if you didn't come up with a regional project, then each one of those providers would build their own local reliability project, because they have reliability standards that they are required to meet.
Let me ask a non-record question here. What is the likelihood that some U.S. senators or congressmen from a jurisdiction like California that's trying to go green aren't going to put a finger on all the local regulators and say there is no way that we are going to allow you to participate in cost?
I don't have any way to speak to that, except I can, going to your earlier question about.
Isn't that just as much common sense as the idea, the inherent naive, quasi-economic idea that if you build it, they will come? 'Cause
Well,
if
first-
you build it and they hate electrical, fossil fuel or nuclear power, God forbid, then they're not going to participate.
Except that there are reasons that they might actually want to participate, such as the category of public policy projects. That could be that a particular utility's jurisdiction that they're in is requiring a certain percentage of renewables or something on the grid. But the point is that each one of these utilities has its own requirements within its territory, reliability in particular, plus their state public policy objectives. This is not about picking and choosing which one of those is favorable as a policy matter. This is about saying if utility 1, utility 2, and utility 3 all have reliability needs that they're required to meet locally, if there's a project that meets those 3 needs, or if it's public power, not public policy, I'm sorry. If 3 of them have different states telling them they have to do something, connect more wind or something, whatever it is, and each one of them is trying to do it individually, if there's a project that does it for all 3 of them, that's what the regional project is. But there's no moral part of this saying it has to be X or Y. It's just saying if the individual territories already have to do this thing, but you could actually save the ratepayers a lot of money by doing the same thing together regionally, that's all this regional planning is about. But
Ms. Banta, let me ask you, it sounds like you may have about answered Judge Jones's question. Let me take it a slightly different direction. There's a hypothetical in the petitioner's brief. You say it's made up numbers. It is made up numbers, and you can make up different numbers. It seems to me, and your numbers could show how when you take out the non-participating, non-jurisdictional utilities, that the project would not meet the ratio, and they can make up numbers that say that it will. At this stage, it seems we don't know. What I'm concerned about is a point made in one of the briefs. When is there a point of no return on one of these projects? So projects in the planning process, the jurisdictional, non-jurisdictional is all in there. Some project looks like it'll be a good one. The non-jurisdictionals won't participate. You redo the numbers. It is over the ratio, which I think means it can go forward. Maybe it's, you still have the ratio met. When is the point of no return on this? When are, to look at in terms of the filed rate doctrine, when is all this set in stone and there's no reconsideration by FERC that maybe this isn't the right way to proceed anyway and we need to modify what we're doing?
on a given project, I'm not sure. If it's planned in accordance with the tariff,
I'm just saying when is everything just set in motion and there's no stopping it? I mean, once you know who is not going to participate and you redo the numbers and it still meets the ratio, I mean, is it over and the project goes forward, or can this not look like FERC has really made a very good plan after all, and maybe we ought to change how we're operating? We meaning FERC.
well, certainly if the commission had evidence of actual projects where non-jurisdictional utilities were declining to participate, it would act on that record. It doesn't have that record because there haven't been any projects, there hasn't been any non-participation. But I can say with reliability projects in particular, as the orders noted, that because every utility has its own reliability requirements, the jurisdictional utilities could say, forget it, we're gonna build our own local upgrade. Now, they might have to deal with their own ratepayers on that because they're turning down something that, if it passed this test, already benefited them 125%. They're getting a 25% higher return than what they're paying on the costs. But if they could justify that to their own ratepayers and say, we'd rather build our own, that's gonna be more expensive. And to be clear, anything they build on their own instead of that regional project will be more expensive because the standard for a reliability project, or the costs being, or the benefits being evaluated on a reliability project are the avoided costs of the thing you didn't have to build yourself. But they always have the ability to say, never mind, we'll build our own, we'll do it ourselves, and we'll pay more, and we'll deal with our own ratepayers on that. So for reliability.
Well, let me ask you this. What is the core concept here? Talk about whether the Federal Power Act actually gives you the authority. There's been some discussion whether the Federal Power Act really gives FERC the authority to regulate these non-jurisdictional utilities. So what is the principal basis behind proceeding the way that you have, which is allowing on incentives and whatever, as opposed to requiring everybody? I mean, my understanding from both sides is in the past, no one was required to share in the costs, and it was done voluntarily in the West with all this interconnectedness, and somehow that worked, apparently, is what both sides seem to agree. So this time it's decided just to require one, the jurisdictional ones. Is there a sense that you don't have the authority, you don't want to press it to require the non-jurisdictional, or I'm just not understanding why fundamentally this is the approach that FERC has taken?
Well, I don't know, the commission, with regard to 211A, which the commission could invoke to require things of otherwise non-jurisdictional entities, the commission said in Order 1000, and was affirmed by South Carolina, that it was not going to do it on a blanket basis, that it had the discretion to, but it wasn't going to do it without a record. As I said, there's been no record, not only in Order 1000, but here in the West Connect region, there has not been a record of the non-jurisdictional utilities refusing to participate or refusing to take their share of cost allocation, because there hasn't been any for them to decline, so we have no record of that harm. The commission said in these orders, as it said in Order 1000 and as was affirmed by the DC Circuit in South Carolina, that if and when we have a record of harm, we will act on a case-by-case basis, but we don't have that here.
Yeah, but their response to that is that your rate making is all prospective, so by the time they have lost money on a bad calculation, they can't recover it.
Well, that's a function
Is that
of...
accurate or not?
It is, but that's a function of the filed rate doctrine, which this court said in Louisiana.
That's a problem.
Well, but it's the law. In Louisiana Public Service Commission in 2014, there were two 2014 cases. This is the 761 F3rd. This court recognized that if the commission approves a tariff as just and reasonable, and later changes it under 206, that's prospective and there's no retroactive relief, and that's a function of the filed rate doctrine, and that's what this court said, like all other courts. But to be clear, the court, or the commission here, and I think this goes back to what I was talking about, when the commission looks at the West Connect region, and it was looking at all the different considerations under Order 1000, and again, not mere policy goals, but actual findings of what will produce just and reasonable rates. And it is a balancing, because we do want to minimize free riding. There was always free riding before. If the jurisdictional utilities built something for themselves and didn't even involve the non-jurisdictional utilities, there would still be some free riding because they're going to benefit from some of that.
But if they did it voluntarily, that's an entirely different thing than telling the non-jurisdictionals, we authorize you to free ride.
But, well,
I assume that the overflow, the free riding would have been much smaller.
we don't assume that, because here there's a mathematical formula that limits the extent of free riding. And the more they might benefit from the free riding, the more likely they end up tanking the project and getting nothing.
But you've changed that formula to eliminate the detriments of free riding and retain only what you think the utility will gain.
Well, no, that's not correct, because it still remains true that the more the non-jurisdictional utilities would benefit, the more likely their non-participation kills the whole thing and nobody gets anything. Even from, if you change the numbers in that
Which doesn't, but that doesn't translate into, and therefore the jurisdictional utilities will willingly raise rates at the detriment of their, or have to absorb the cost without a rate rise.
well, to be clear, whatever they're getting under this formula, they're saving money over doing it themselves if it weren't regional, because if they don't pass
Only
that
if there's planning and transmission, and for some reason there hasn't been a bit of it in the last 10 years.
Well, and I don't know the reason for that, and that we don't have a record on that. As I said, the commission has acted in other jurisdictions when it felt that Order 1000 was not being applied, not being implemented correctly. It hasn't done so here, and it hasn't said anything
Let
about
me
it.
ask you a question. If we find that this case is just flat controlled by our previous case because FERC has not advanced a single new fact or rationale that is different from the one of our previous case, why should we remand? Why shouldn't we just vacate Order 1000 as applies to West Connect?
I don't know that.
How often do we have to defer to the commission's ability to impose something that isn't just and reasonable, if we were to decide that?
Well, I mean, I would say that the previous court said numerous times that the commission hadn't explained its reasoning and hadn't explained why it thought this mechanism would limit free riding, and the commission provided extensive explanation on that here. So we believe that the commission did respond to the mandate of this court by providing substantial explanation. As I said, that if the more the non-jurisdictionals benefit from a particular project, the more likely they could kill it if they didn't take their cost allocation. There hasn't been any discussion in the record or any proposal by petitioners that West Connect be exempted from Order 1000, so I wouldn't even know where to begin to speak to something like that. But I will say that the commission, as I said, in Order 1000, the problem that the commission found to be a violation and not producing just and reasonable rates, in fact, producing unjust and unreasonable rates, was the lack of efficient regional transmission planning. And that's what the commission's trying to balance here in trying to minimize free riding, to maximize the number of projects that could be identified, and to reject limits that would exclude undisputedly beneficial to the region projects, where even the jurisdictional utilities would be getting more than 125% of what they were paying for. The commission balanced those and said that produces just and reasonable rates for ratepayers. And
No, just and reasonable rates aren't what the ratepayers get. That's what the utility gets.
well, but it's all about passing. I mean, the ratepayers pay for it.
Well, I understand that, but the utility has to have enough money to survive, right?
Well, and if it has a project,
Ratepayers are the ones whose ox is gored if, in passing along the cost, if to put it very bluntly, if the ratepayers of El Paso have to bear the cost of the consumer in Los Angeles getting an extra share of electricity, that's certainly not just and reasonable. But more than that, El Paso Electric has to be able to recoup sufficient to continue to serve the El Paso consumers.
I know I'm past my time. Can I respond to that?
Of course.
Say it's a reliability project. El Paso has to build that project, and it has to build it at whatever it would cost. If that project passes this test, even with the non-jurisdictionals not taking their cost allocation, it is only because the El Paso is getting 25% more than it's spending. And benefits are the avoided costs. So it is getting back in benefits more than it's avoiding the cost of the thing it had to build itself. So the El Paso ratepayers would unquestionably be paying more if the whole project falls apart, or if it never happens in the first place because we don't have this mechanism. Under this mechanism, those ratepayers will be paying less than if El Paso says, I'll build my own reliability project, we're not going to do it regionally, or if it's not done regionally under this. So that's just a given that they're going to get that 25% more. So El Paso has the money and the ratepayers benefit from it. And there's no way around that, because if it's 24%, if it's 124%, that project fails this test and does not go forward. It does not happen. They do build their own, which might still be at more expense. They might only get a 15% return. They still would have been better off with the 24, but it won't happen because that's where this test draws the line. And I'm,
Ms. Banta, with the presiding judge's permission, I have one more question for you. You talk about minimizing free riding. When would a court be, in your view, validly deciding that there's too much free riding? This case comes back to us. If let's premise that we approve what you're doing. When could somebody complain there's too much free riding under this? Is there some, is it strictly a matter of deferring to the FERC and we decide whether you're arbitrary and capricious in what you decide, or what should we be looking for? What should FERC be looking for?
well, the commission always starts with the roughly commensurate test that there's no requirement in any case that free riding be eliminated entirely, because we have reams of cases that we've cited that.
Okay, you got a base that says that. What I'm talking about, when are you above that base where a court could act? And it seems to me on the FERC's approach here, we have to take an awful lot on faith. But at some time, let's say we do, at some stage there will be more than faith involved. When does it become actionable?
I don't know that we have a number for that, because it's always going to depend on what the commission was balancing to produce just and reasonable rates. I would offer a couple of citations for where courts have found 25%, even potentially 25% of so-called free riding to not cross that threshold. The Seventh Circuit in MISO transmission owners, it's a case from 2016, so I don't know whether it's cited here, but I have the site for you. It was a Judge Posner case.
Well, don't give us any sites now. You're already over your time. Why don't you
Okay, well,
provide
it's
what you're
discussed
about
in
to
Old
tell me
Dominion, so
in
it's
a
discussed in
follow-up
Old
letter?
Dominion.
Old Dominion?
The Old Dominion case that is cited has a paragraph that discusses what the Seventh Circuit characterized as a modest spillover of benefits. In that case, there was a question of local reliability projects that would be allocated all to one region, but historically, these kinds of projects had spillover benefits of, I believe, up to 25% for other regions, and there was an argument that you couldn't allocate it all locally because it's benefiting people outside the region, and the Seventh Circuit said that it didn't fail the roughly commensurate test, and the DC Circuit discussed those numbers a little bit more in the Old Dominion decision, so I can at least offer that. I'm not saying that's what the number is, but in the context of balancing all the other considerations and why the commission is doing it and what the commission thinks the ratepayers are getting a just and reasonable outcome from it, that all goes into the mix. So I'm only just offering that as a citation for showing that no court has required close to 100% matching, if that's helpful.
Thank you.
All right, thank you. All right, Mr. Reiter. And which utility technically do you represent?
Your Honor, the utilities that I represent are the Salt River project in Arizona, the Colorado Springs utility, Platte River, both of them are in Colorado, Tank, which is an association of municipal utilities in California, the Los Angeles Department of Water and Power, and the Sacramento.
Basically all of them.
Yes.
Okay.
Yeah. I'm sorry.
That's okay.
Just to answer your question from before, Your Honor, none of the governmental utilities in this case are regulated by their respective states. They're regulated either by, in the case of Los Angeles City Council, or by an independently elected board.
That's my point. They are regulated by somebody.
Yes, they are. And that their independence was one of the reasons why the commission had said, since they're not subject to FERC jurisdiction, FERC could not require, and the petitioner agreed 10 years ago that under Order 1000 they couldn't require them to enroll.
Well, I understand that, but I mean, this whole, start talking. I'll ask my questions later.
Okay, thank you, Your Honor. El Paso's core argument in this case is that FERC's order unlawfully permits unlimited cost shifts. That's their words. And that given the choice, the non-jurisdictional utilities with whom they've cooperated for years, and as this court said, are interdependent on one another, will suddenly become a bunch of freeloaders. Now, taking advantage of projects for which they won't pay. Now, putting aside the ill will that would create among utilities that have to continue to cooperate with one another, they're interspersed throughout the region. There are three fundamental flaws I'd like to address. One is the argument that the cost shifts are unlimited is just flat out wrong. There's a cost ratio benefit test that has to be met. So if there are defections among some non-jurisdictionals, there's a limit on how much the jurisdictional utilities would pay. In any case, they'd still get benefits well in excess of the costs they would pay for these projects. Second, their argument in this case is that Order 1000 requires elimination of all cost shifts or subsidies, and that's not correct. I mean, they equate a difference in rates with being unreasonable, but the statute prohibits not differences in rates, it makes unreasonable differences in rates. Those are the words in the statute, unlawful. So by definition, the court contemplates that there will be, or the statute contemplates that there will be differences in rates charged.
It doesn't contemplate that, maybe I'm embodying the premise that you say is not there, but it does not contemplate that the jurisdictional utility in building additional transmission that everybody in the region decides is important, that the El Paso consumer is going to subsidize the Los Angeles consumer.
And, Your Honor, the point, I think, is that there's always going to be some subsidy because you can't create perfect rates.
How much electricity does the LA municipal system generate?
Quite a bit, which I think makes my point that I wanted to get to, if I could, Your Honor, about the non-jurisdictional's declining cost allocation. The petitioner and the interveners supporting the petitioner say that there's no economic theory to support the Commission's predictive judgment. The courts have said that an agency is entitled to deference with regard to predictive judgments that they can defend.
The tragedy of the commons is that when everybody can go and graze their sheep in the commons, then
But they can't. That's the point, Your Honor.
well, you say they
Let's take the case.
won't.
Your Honor pointed out that there's been no projects for 10 years. That's, in fact, our concern, too. There've been planning. There has definitely been planning during all this time, but no projects have been found to meet even the minimum 1.25 to 1 benefit ratio. Now, let's take that case. Let's say you've got a case where there are 25% more benefits than cost. If there's a single defection by a municipal utility, it won't go forward. So the Commission reasons, logically, that, let's say that a multiple municipal utilities that are sizable might say no, and then the project would fail. But if one of them did it, they'd get their free ride. Well, one can't know what the other is going to do, so acting logically, the Commission doesn't use the term, but economists call it game theory, that you know what you can know, there's some things that are unknowable. The Commission says, acting rationally, municipal utilities are not going to say no in order to get a free ride if they face the bigger risk that there's no project at all, a project from which they would have benefited. So I think the Commission was well within its reasoned judgment to make...
Unfortunately, you can't make up better reasons than the Commission had, and they didn't say a word about game theory.
No, they did. They didn't use those words, and as this court has said, and as the Supreme Court has said in the State Farm case, what the Commission needs to do is, it doesn't have to have perfect clarity, but if you look at what the Commission says if you bear with me a second, there are a couple of passages where they describe exactly this without using the terminology. If you can look at Joint Appendix sites 1294 to 95, 1945 to 46, they point out that there's a risk to these non-jurisdictional utilities of saying no. They'd be cutting their nose to spite their face, to say, okay, we're going to forego a project that might be beneficial to us in the hope that we get a free ride. The petitioners they came up with one hypothetical, it was a pretty dramatic one, where almost a 2-to-1 benefit ratio, and even that one was kind of speculative.
I'm giving you a lot of extra time, but I have specific, and I understand that point. What is the point of this settlement? FERC did not appear, our court gave everybody 2 or 3 years to work out a settlement. I understood that your client and the jurisdictional utilities had worked out.
Yes, Your Honor.
And then FERC prevented it.
Yes, that was a disappointment to us, and we all worked hard on it. We negotiated that in good faith. I mean, I can tell you what one of the central provisions in the settlement was for both of us, it's
Please.
filed, it's not a secret, was something called a memorandum of understanding, that if we decided that a project was worth our while, we would enter into a memorandum of understanding that we'd have a commitment to argue to our independent boards that we should go forward with the project. And that was to give the jurisdictional utilities some assurance that we would keep our word. We have the right to say no, because the boards, for their own reasons, not to get a free ride, but because they're independent entities.
In other words, you had this voluntary commitment to go back to whoever regulates you, who could have prevented your clients from participating. So you undertook that volunteer, and FERC said that FERC apparently thought that was not consistent with Order 1000.
Well, there were other provisions that they rejected as well.
How much of this is public?
Their order rejecting the settlement is public.
Okay.
They articulate all their
Is
reasons.
that in the joint appendix?
None of us have appealed that. No party sought review of that denial of
Okay.
the order.
All right.
I know I'm well past
You
my
do have
time.
your brief.
Thank you.
Okay, thank you. All right, Ms. McCormick, I'll give you two extra minutes on rebuttal.
Thank you, Your Honor. I'm gonna, I think, work a little bit backwards here. I wanted to address Judge Southwick's question about what is the point of no return. If you will look to page 314 of the record, that is FERC's first compliance order. It confirms that the cost allocation method that we're talking about today becomes binding once these tariffs are, if they're approved, any cost allocation becomes binding at that planning stage, and at that point, it can't be changed for any project that's identified. Even if FERC were to say that the cost allocation method later, they think, well, we could have done a better job at that. It would only be changed prospectively, and any projects that had been identified under the old method would be stuck with it. So I also want to point out that the fact that West Connect has not identified any regional projects under this planning process that we're talking about today doesn't mean that no projects are being built. It's just that no projects are being built under this regional planning scheme.
So the jurisdictional utilities are in fact going out on their own?
In some situations, yes. So,
Let me ask you about something Mr. Reiter said, I believe, somebody spoke since you, that there have been projects proposed, but they just never met the mathematical formula for approval. Is that correct? They never had enough benefit to go with the cost?
My understanding is no projects have been identified. And I do want to talk about the mathematical formula because FERC really hits that hard.
Well, let me stop you there. Did you hear was it Mr. Reiter who mentioned that? It sounded to me as if you were saying some projects planning had occurred, but none of the projects met the financial requirements to justify them going forward. Is that something you understand to be true?
I do not understand it to be true that the West Connect planning region has identified regional projects and that they have just become ineligible for.
They're not economically viable is I think basically what he was saying, but maybe I misunderstood. If you're not aware of that, just proceed.
The mathematical formula that FERC is relying on has several variables, and there's nothing that suggests that those variables are going to ever, much less always, combine to make a project fail the test. That just defies common sense. And the non-jurisdictionals are entitled to participate in this entire process. They have access to all of the details. And so they're going to be able to handicap the chances that a project will still pass the test, even if one or more non-jurisdictionals declines to pay its share. And we keep hearing from FERC that this idea that as long as you're getting a good deal, i.e. your benefits exceed your costs, then you should be happy and the rate is just and reasonable. But that's not correct. The non-jurisdictionals can actually see that they can get an even better deal if they pay nothing. Their net benefits are much greater in that situation. So that's actually an incentive that it's the opposite of what FERC is articulating here, and FERC just ignores it. The last thing I want to address is the idea that there is some tolerance for imprecision in applying the cost causation principle. But the cases that the cost causation standard tolerates imprecision when there are, it's difficult to identify beneficiaries of a project or when it's difficult to quantify costs and benefits. But that's not the type of imprecision that we're talking about here. Here, the West Connect process enables everybody to know the universe of beneficiaries for a project, and it clearly quantifies benefits and costs for everyone. No one disputes that that happens. What FERC is doing is taking the costs from people who caused them and putting them on the backs of someone who didn't cause them. That's not imprecision. It's impermissible socialization of the costs. And this court recognized that when, the court in 2016 acknowledged that cost causation doesn't always require exacting precision, but despite that, the court still found that this scheme is unjust and unreasonable. And I believe I have,
two questions. Number one, do you think we're bound by El Paso Electric as a matter of stare decisis? Number two, what will we do if we agree with your position?
Question number one, I think it's law. The 2016 decision is law of the case. Same parties, same issues. All you have here that's new is really not new. It's just an elaboration on this idea that the mathematical formula is somehow going to incentivize people. And on the second question, we request that the court vacate FERC's orders, send the case back to FERC with instructions to find a solution that actually adheres to the cost causation principle under the circumstances of West Connect. And it looks to me like my time has expired.
Okay, thank you very much. Judge Southwick, no more questions?
If I can unmute myself, I do have one more question. There was a question raised earlier about Order 1000 itself. Order 1000 itself is not at issue in this appeal, in this petition, is it?
It's not. That's correct.
All right. Thank you.
All right, thank you. The court will stand in recess.